Call the first case. Case number 113412, estate of Terrell L. Graber v. Dillon Companies.
May it please the court, Dallas Rakestraw on behalf of Kroger, Dillon's Companies, and Sedgwick CMS. With your permission, Your Honor, I would like to reserve 3 minutes for rebuttal time.
3 minutes is granted.
Thank you, Your Honor. May it please the court, this case is a simple case involving a matter of statutory construction. Namely, it involves the determination of the term idiopathic cause as codified at KSA 44508 F3A4. The facts of this case are fairly straightforward and are not in dispute. Mr. Terrell worked for Jackson Dairy, which is a subsidiary of Kroger. It is located in Hutchinson, Kansas. On Sunday, August 21st, 2011, Mr. Graber attended a safety meeting at Dillon's headquarters in Hutchinson, Kansas, which is adjacent to the dairy. The safety meeting was approximately 7 hours long. Following his attendance at the safety meeting, he then proceeded to he went to the restroom. He had no recollection of what happened after leaving the restroom. His only knowledge, his first recollection after leaving the restroom was being loaded into a helicopter to be transported to Wichita, Kansas for treatment. During the interim of his blackout, he fell downstairs. He sustained an injury to his neck and face. There is no explanation as to why the fall occurred.
Is there any evidence to support the idea that the fall resulted from some unknown medical condition or medical event?
There is not evidence of that in the record, Your Honor, that I am aware of. In fact, I believe the claimant's expert, Judge Dr. Fluter, indicated that it was not a result of his personal diabetes, though the gentleman was diabetic and was controlling his diabetes through medication following a liver transplant.
Is that important, whether there's any evidence of this being the result of an unknown medical condition or medical event?
It would be important to determine whether or not we will go to what subsection of 44508F is applicable in this case, Your Honor. This case occurred following May 15, 2011. On that date, the Kansas legislature dramatically overhauled the Kansas Workers' Compensation Act. Prior to that date, the Kansas Workers' Compensation Act did not contain a definition of arising out of and in the court arising out of. Following the 2011 amendments to the Kansas Workers' Compensation Act, that was codified by statute for both repetitive trauma cases and traumatic event cases. There is also, at that time, an exclusionary provision included in the Workers' Compensation Act, which is the main gist of today's appeal. The exclusionary provision is at 44508F3A with 4 separate subsections. One has to do with the natural aging process, activities of daily living. 2 has to do with neutral risks of no particular employment or personal character. 3 has a personal character. And 4 has to do with injuries caused either directly or indirectly by idiopathic causes. This is a long way to answer your question of if there was a medical condition involved. I think that this case would center around whether or not the third provision of 44508 F3A applied versus the fourth provision.
Right, but you're only here on the fourth
That
provision.
is correct, Your Honor.
And so as it relates to the fourth provision, is it important that there's no evidence of this being some kind of an unknown medical condition or medical event?
I think it's significant, especially when considered in light of the definition utilized by the Kansas Court of Appeals. The Kansas Court of Appeals decided to utilize the Bennett v. Wichita Fence definition of idiopathic having some personal relationship to the employee. I do not believe that that's the plain language definition of idiopathic. It is a past definition that has been used. If that statute, if that interpretation stands, then this would not be an idiopathic cause. But if you were to follow this court's instructions regarding the plain language of the statute, and that would be the guiding force of how to determine the meaning of the statute, then the fact that there is no evidence of a personal condition would lend credence to the fact that this is an unknown cause or an idiopathic injury. So I would think it would be significant at that point, Your Honor.
And then that's kind of the problem I've been having with your position on this, because when I think about common meaning, and that's where I'd like to be, when I think of the word, you want to make the word idiopathic mean unknown, period. And when I'm thinking of synonyms for the word unknown, idiopathic never shows up in my mind. So to me, that doesn't seem to fall into a common meaning kind of setting. Plus, if the legislature really meant unknown causes, all they had to do was say unknown, which seems more natural.
Well,
and so why wouldn't we take idiopathic, that term, that word, and use sort of the other treatises on workers' compensation, the other case law on workers' compensation, and tie idiopathic to medical condition or medical event? That's kind of the heart of what we're about here, I think.
Well, I think that when you look at this court's past precedent with the regard to the word idiopathic, you do see that idiopathic has been used by this court to mean unknown causes. This court in 2010, in Cuxhausen v. Tillman Partners, did use it to mean an unknown cause. That had to do with the premises liability. In State v. Massey, which was a 1972 case, this court used it to mean an unknown, the definition of unknown, idiopathic meant unknown. So it's not beyond the realm of this court to define idiopathic as unknown. It also is consistent with the dictionary definition of unknown, which, as outlined by the Court of Appeals, at least 3 different dictionaries that were utilized by the Court of Appeals indicated that it arises spontaneously or for which the cause is unknown, spontaneously or from an obscure unknown cause, arising spontaneously or from an obscure unknown cause.
Counsel, isn't what you're reading there only half of the word idiopathic? And I don't want to delve into the Latin root necessarily, but doesn't the second half of the word pathic, doesn't that constrain the definition to mean some kind of disease or condition? So and just to follow up on that, it sounds like you're arguing that if this gentleman was pushed down the stairs and nobody knew about it, that would be an unknown cause. That would qualify as an idiopathic cause. But it strikes me that the word idiopathic has the feature of it being unknown, but it relates specifically to a disease or a condition. And I just want to get your response to that.
Absolutely. I think it raises a good point. If you were to construe it as only a personal condition to the individual, then you are reading it to render other provisions of the statute redundant. And this court has indicated that when you interpret a statute, you should do so in pari matria, which would
that might be a reason to ignore or set aside the plain meaning of idiopathic, but just for the purposes of my question, doesn't idiopathic, just as a word with Latin roots, doesn't it mean an unknown disease or condition?
According to the dictionary definitions I've consulted, it says peculiar. The only one that gives another definition is Webster's Unabridged Third International Dictionary, which gives idiopathic as being peculiar to the individual or arising spontaneously or from an obscure or unknown cause. Merriam's Dictionary Online, arising spontaneously or from an obscure cause, or as particular to the individual.
But what is arising? It's a disease, right? We're talking about pathology.
But are we? In workers' compensation, are we talking about that? Because in this case it says caused or caused either directly or indirectly by an idiopathic cause.
Okay.
The definition would seem to indicate that it could be anything. My point regarding the in pari matria is that each of these subsections has to have its own meaning. If you are saying that the idiopathic has to be a personal condition to the person, then what's the point of having the third section, which says it arises out of a risk personal to the employee? If the individual has a personal condition, be it diabetes, be it a heart condition, be it a syncope condition, that would be personal to the individual. If the idea of a neutral risk, which is where the Court of Appeals seems to hang its hat, is that McCready this court said, the Court of Appeals said an unknown fall is a neutral risk. It seems to me that that's somewhat that all of these can be jived correctly together. You can say that a neutral risk, as this court has previously said, is the result of a known event. This court has previously said so in the Hensley v. Glass, where it was a sniper's bullet. Previously also this court has said that an unknown risk is due to a death by tornado or a death by an assailant. Those are outlined in my petition for review, the Faulkner v. Yellow Transit. In all of those conditions, the risk is known. The absolute risk is known. It is not peculiar to the individual. It is not peculiar to the person. So the neutral risk there is a known entity. If you go to the personal risk is known to the individual, be it a condition of diabetes, syncope, heart disease, that condition is known to the individual. If you use the definition of idiopathic cause as unknown, well then what you're doing is shoving these unknown fall cases over into the idiopathic condition, and you're consistent with the plain language of it being an unknown cause, and each of these provisions then has meaning.
We also have a rule of statutory interpretation that if you have words that are used in a specialized context, we look to the meaning that's given in that general specialized context. So not necessarily what you would look for in the plain language, but what is it understood in this context? And isn't it true that when you look at Larson's and other treatises and sources about workers' compensation, that we do have a very specialized meaning about idiopathic in the case law? And that is related back to, as Justice Stiegel was saying, to pathology, to a health condition of some sort.
That may be correct, Your Honor. But by doing so, you're basically rendering that statute irrelevant.
So I think we may have conflicting statutory interpretation issues here.
Good luck.
That's the question. So then which one rises above the others?
I think that if you are to follow the intent of, I'm sorry, I'm over my time. May I respond? I think that if you are to follow the intent of the legislature, which is the lodestar that this court follows in statutory interpretation, then each provision of 44508F3A has to have a meaning. That would mean that each of the subsections would have to have a purpose. You would have to give effect to each provision that the legislature has enacted. You would need to do so to follow, in that case, to make sure that each provision is enacted. You would need to not look at Larson's. You would need to not look at other states. You would need to look at this state, what this legislature has done, and what this legislature has enacted. And in this case, they have enacted 4 separate provisions. A provision that deals with activities of day-to-day living or natural aging, a provision that deals with neutral risks, a provision that deals with personal risks or personal conditions, and an injury, and a provision that deals with idiopathic. This court needs to give meaning to each one of these statutes, each one of these provisions of the statute. If you do not, then you have rendered one of them meaningless. So if you utilize this idea of idiopathic as personal to the individual, you have effectively rendered 4 or 2 redundant. That cannot be the intent of this court. That cannot be the intent of the legislature. So therefore, in interpreting that and following the guide star of the intent of the legislature is not to enact redundant or meaningless provisions, this court would need to give meaning to each of those provisions. So that would be how you would reconcile that difference of opinion, Your Honor.
What, in your view, when an injury occurs in an unexplained kind of a way, like here, what happens to the Mr. Grabers of the world, or the workers? I mean, what is he just without a remedy?
He is not without a remedy. He obviously has a suit against in tort. He does not have a remedy under the Workers' Compensation Act, but there is no reason why he could not sue on a premises liability suit against Dillon's in this Kroger in this case. It occurred on their premises, and
It just seems to defeat the overall intent of what workers' comp is designed for, is that injuries that occur and arise out of employment and in the course of employment get compensated for the trade-off of not having to have to file a premises liability kind of case.
I would agree with you that it is somewhat different than the standards that have previously governed workers' compensation law. However, the idea of risk analysis is not a new part of the workers' compensation case. This court since the 1970s has put forth risk analysis. What happened in 2011 was a codification of risk analysis in statutory form, which is the prerogative of the legislature, so long as they have not deprived the individual of some type of remedy.
Adequate remedy.
An adequate remedy.
Adequate substitute remedy.
And I would submit to you, Justice Johnson, that in this case they still have an adequate remedy, since the remedy at tort has not been removed, since you are no longer have sustained an injury arising out of and in the course of employment. But that does not mean that you have not sustained an injury on another's premises and would not be able to pursue tort claim under that. And in that case,
What's the theory of a tort claim for an idiopathic causation that starts with something we don't know?
I'm not saying that you will have a recovery. I'm saying that you have a right to a recovery. I cannot guarantee you recovery either way.
Isn't part of the workers' compensation statute, though, designed to take away those kinds of issues for the worker, to provide them compensation without having to go through that, what would probably be a futile process?
You're saying that
Isn't that really at least in part, the underlying purpose of the workers' compensation statute?
Well, in 1911, when the legislature invoked or put in place the Workers' Compensation Act, it is to provide speedy benefits to the claimant so that they don't have to go through the process. It is not a guarantee at all that every injury that occurs on the premises is entitled to workers' compensation. The claimant still has the burden of proof to establish that they have sustained an injury arising out of and in the course of employment. Simply an injury occurring at the employment does not guarantee injury. The same would be if the person were to, the difference in this case is what had happened if this gentleman had a diabetic seizure at the top of the stairs and had fallen down the stairs because of the diabetic seizure. In that case, we would be under the third provision of a personal risk, and he would not be entitled to compensation benefits at that time. So risk analysis is inherent to the Workers' Compensation Act. Simply sustaining an injury on the premises does not automatically guarantee the worker compensation benefits. They must still carry their burden of proof as required by 44501B. The claimant still has the burden of proof to establish their right to benefits, and to do that under that same statute, they must establish that they sustained an injury arising out of and in the course of a personal injury by accident arising out of and in the course of their employment. This is exclusionary to that arising out of, so it's really codifying what has already existed and this court has already put forth.
Do we have any further questions? Thank you, counsel.
Thank you, Your Honors.
Good morning. My name is Jan Fisher. I represent the estate of Terrell Graber. I'm not going to focus on the meaning of the word idiopathic because I think that it has been looked at in the initial, that because of the word pathic, you use that definition that refers to a personal or innate condition. The Court of Appeals has done a tremendous job in setting out all of the cases in Kansas that use idiopathic in the context of a workers' compensation case, meaning innate or personal to the claimant. That's also consistent with various other states. You'll see that in my original brief, as well as the Court of Appeals, where virtually every state that's looked at the issue, including Missouri, including Colorado, including Nebraska, all say in the context of a workers' compensation case, the word idiopathic means personal or innate. That's also what Larson's on Work Comp says. That's also what other learned treatises say. So I want to talk a little bit about this idea.
Before you get started on
Sure.
another path there, some of those cases predate 2011.
Yes.
And don't we presume the legislature knows the law when they pass a new-
Absolutely.
Okay. But we also presume that when the legislature changes the law or makes a new law, they intend to change it.
I agree.
So how does that dovetail into carrying the prior definition forward?
Because the statute doesn't simply say an accident by an idiopathic cause does not arise out of. What it says is an accident does not arise out of if it is directly or indirectly from an idiopathic cause. And frankly, I think that is the crux of the argument, the reason why it means personal or innate. What does directly or indirectly refer to? Well, if you think about it using the definition that Dillon's would have you use, unknown cause, that doesn't make sense with directly or indirectly, because you don't know what happened, so how do you even get to directly or indirectly? But if it means personal or innate, as in a personal health condition, it does make sense. And it's specifically directed at those line of cases which start with Bennett versus Wichita Fence, where we had a mixed risk situation.
How does personal or innate not render F3A sub 3 redundant, like your opposing counsel argues?
Well, a couple of reasons. One, it's redundant somewhat either way, because if it means unknown, it's a neutral risk. So it becomes redundant with, is it the third?
Yeah,
Subsection.
I think the second, or at least, I think the second is the neutral risk.
Right.
Third,
Two.
risk, personal risk. Fourth, idiopathic cause.
Correct.
I don't want to interrupt that flow, but I don't understand that point. So, but why don't you go back and finish answering Justice Stiegel, but then I'd like to return to that.
Okay. Secondly, if you look at especially 44508, when they chose to change the law, there's quite a bit of repetitiveness in the law. For example, if you look at what we start with, which is KSA 44508 F2B, it says, arising out of, there is a causal connection between the conditions under which work is required to be performed and the resulting accident. So you have to prove a causal connection. Well, then underlying it says a personal risk is not compensable. Well, if you have a personal risk, you don't have a causal connection. So in some ways, there's just built-in redundancy within or built-in duplicative statements within the statute. But more importantly, I think the directly or indirectly answers your question, because we have work risk, we have neutral risk, and we have personal risk. We also have mixed risk. We have things that happen partly because of a personal condition and partly because of a work condition. For example, someone has epilepsy, they have a seizure while driving a company car on company business. That's the scenario in Bennett versus Wichita Fence. We have a mixed risk situation. We both have the seizure causing the car accident, but the fact that he has to drive for work increasing the severity of the injuries. That's a work risk, increasing the severity of the injuries. So I don't think it's duplicative because it includes that directly or indirectly language, which I believe is focused on the idea of not only is a pure personal risk non-compensable, but a mixed risk situation is non-compensable when it's both a personal risk, a personal health condition, and a work condition. Now, if I could answer your question.
Yes, I understood it. You just say there's overlap between 2 and 4 because of the neutral risk. You don't know what that is necessarily, the cause of that necessarily is. But how do you then apply the words in that provision that says with no particular employment or personal character? Don't you have to know what the neutral risk is in order to make the evaluation of those criteria?
A neutral risk has previously been defined in a case called McCready, well, first of all, in Hensley versus Glass, in the case called McCready versus Payless, which is cited in my brief, as two basic things. We don't really see it as a personal risk. We don't really see it as a work risk. And the categories that fall in that are an unexplained fall on a flat surface, or a shooting or some other assault for no work reason or no personal reason. And so if it's unexplained, if it's an unexplained fall by previous case law and by previous treatises, that's always been a neutral risk. Does that make sense?
Right, I understand that. I'm
Okay.
just having trouble understanding the meaning of the rest of the provisions and why they're there. They either seem like you have to ignore them if it's unexplained. I don't know how you determine those things, but I see the same problem really with then applying the either directly or indirectly language of the idiopathic. How do you determine something's direct or indirect if you don't know what causes it?
I don't think you can. That's one of the reasons why I don't think that the definition of unknown or unexplained is the correct definition. But I think you can understand it if the definition of idiopathic is personal or innate, because you have a mixed risk situation. Neutral risk is like saying we don't know what the risk is,
Right.
or unknown risk.
Right. So we can't tell if it's particular to employment or if it's particular to a personal
Correct.
need.
Exactly right.
So those words are impossible to apply, I think.
Correct.
And let me ask you, you cited McCready, and one of the things that's been bothering me is when you look at the legislative history on this statute, there was a lot of testimony which I think sort of was spurring the 2011 amendment, was the McCready case. It was criticized in the testimony to the legislature. And so it seems odd to me that we would hearken back to McCready when it seems like whatever's intended in this garble of language was meant to walk away from language like was used in McCready.
I think that that is correct if you remember that McCready is a pure neutral risk, because Sharon McCready got out of her car and fell for an unknown reason on flat concrete. There was no risk involved in that case at all, no work risk involved in that case at all. There wasn't stairs, there wasn't a moving car, there wasn't anything to indicate that the injury was more serious because it was at work.
So the neutral risk exclusion was meant to get at McCready, not the idiopathic cause.
Exactly. I think it was trying to get rid of those cases in which the only way that the case can be compensable is on a but-for analysis. But for the fact that they were at work, it would not have occurred. So it's those flat surface, no work risk cases where there's an unexplained event, such an unexplained fall. The other thing that I wanted to touch on, and it wasn't really brought up by Mr. Rakestraw in oral arguments, but it was brought up in his brief, is this disturbing idea that he substitutes the word accident for risk in the F3 sections. So what his brief tries to do is it tries to take the prevailing factor standard and substitute it into F3. So you'll look and see he substitutes the words in, and he'll go, the prevailing factor in the personal risk is, the prevailing factor in the neutral risk is. Well, the statute does not apply the prevailing factor standard to the cause of the accident. KSA 44508F2B, which is what we look at for initially arising out of, says, 1, there is a causal connection between the conditions under which work is required to be performed and the resulting accident, and 2, the accident is the prevailing factor causing the injury, the medical condition, the resulting disability or impairment. The statute doesn't say the prevailing, you must prove a prevailing causal connection. But by substituting in the definition of accident for the risk, that's in essence what he does. He tries to apply the prevailing factor analysis to the cause of the event, to the cause of the accident. And that's how he gets his redundancy argument, because he thinks that it applies to mixed risk situation because the prevailing factor applies to personal risk, neutral risk, etc.
It sounds like you're saying that sub 4, idiopathic causes, because it doesn't use the word risk, it has an independent meaning that stands alone, regardless of how we define idiopathic in a sense.
Absolutely, it
Okay.
does. And so I think that the only causal connection you have to prove, you just have to prove there is some work risk, except for the idiopathic section. So mixed risks are okay if it's neutral and work, but if it's an idiopathic condition, it's not compensable because even in a mixed risk situation, because of the language directly or indirectly.
So it's actually a more favorable, it's a carve out. Your argument is that sub 4 is a more favorable carve out for employers. In other words, it's a higher bar for recovery.
Sure.
If there is an idiopathic cause.
Sure. It is an effort to get rid of those entire line of cases that we've had since the 1930s or the 1940s that indicated that when you have for both a personal risk, personal health condition, and a work risk that makes the condition worse, those are compensable.
And let me just ask one more question back to the meaning of idiopathic.
Sure.
And I'll correct myself. I think earlier I talked about Latin roots. I think it's actually Greek roots for this word. But my understanding is that the first part, idio, essentially is translated from the Greek to mean unique or one of a kind. Is that correct in your view?
That's how I understand it. There is a Missouri case cited in my original brief called Taylor versus Syntax. And in that particular case, the respondent argued that the gentleman was driving a vehicle or truck on a work-related errand, and he coughed. And the respondent tried to argue that the coughing is what caused him to go off the road, and that was idiopathic. And the Court of Appeals in Missouri said no, because idiopathic means peculiar to the individual, and everybody coughs for a lot of different reasons, and so it does not comply with the idio. And in the same way...
Well, let's take the question of epilepsy, which has been raised. I mean, many people suffer from epilepsy. So if idiopathic means unique or one of a kind, epilepsy would not be an idiopathic cause.
I don't think that it goes that far. I think that it eliminates, just as the Court of Appeals in Missouri said, those kind of common everyday things like coughing or sneezing or allergies. But if you have a disease, it must mean, and based on the past case law, it must mean if you have a disease process that is unique to you. In other words, you have epilepsy.
What does that mean, unique
public.
to you? I mean, that's the question, right? Does that mean unique to you as against every other person or every other known disease?
I don't think it
pathology?
can mean that. It renders it meaningless. Oh, I'm out of time. Any other questions? Thank you very much.
Thank you, Counsel.
May it please the court. Justice Luker, you raised a very interesting question that I would like to go back and address, and that's that if idiopathic means unknown, how do you tell if something is caused or indirectly caused by something that's unknown? And I think that you need to go back up, look at the statute a little closer. The statute says an injury or accident caused, which is either indirectly or directly caused. An accident is a sudden traumatic event, an sudden undesigned traumatic event. An injury is a lesion or change in the physical structure of the body. In this case, this gentleman fell down a flight of stairs and suffered an injury to his neck and face. The fall down the stairs is the accident. It was a sudden, undesigned incident that occurred. The injury to his neck and face is the damage to his neck and face is the injury. So, because it is a lesion and change in the physical structure of his body. What has caused that accident or injury? What has caused that undesigned traumatic event, and what has caused that lesion or change in the physical structure of the body? And in this case, we don't know. It was an idiopathic cause. We do not know why he fell. So the injury and the accident in this case were caused directly by an unknown cause.
But
We're
the
due
injury,
to an unknown cause.
The injury was caused by the fall. The accident that caused the injury, is what is unknown.
And the statute
So
says injury or accident.
Right. And
So the injury in this case, we don't know why he fell. So we don't know the cause for the injury in this case.
So do both must, it's
written in the
disjunctive.
disjunctive, so either one would exist, and that would preclude it from falling under the definition of arising out of and in the course under the provision. By following that statute, you give meaning to subsection 4. by saying that, and Justice Stiegel, to follow up with your point, if it means individual, it means there's an indirect consequence to it being particular to the individual. Let's take away the idea that you have to have some unknown disease that's never been heard of before, so it's that peculiar. But let's take another example of someone that has a previous ankle injury, and as a result of their previous ankle injury, they fall down. Well, that ankle injury is personal to them, it's pre-existing, they've had it for a long time, and that's why they fall and hurt themselves. Are they now precluded from all claims that have to do with that ankle injury because they have sustained an injury that is personal to them? I mean, we like to talk, and I'm out of time.
Finish your answer.
We like to talk about epilepsy or syncope or diabetes, but more than not, we see people who come to the employment with a previous knee problem, or we see people that come to work with a pre-existing shoulder problem or previous neck problem. Is idiopathic means personal to the person, and in that situation, then there is an indirect cause to their fall, to their slip, to any of their problems. Are they now precluded from injury? Because if it means personal to the person, it seems that opens the floodgates of a whole bunch of pre-existing conditions that are no longer entitled to compensation benefits, whereas the unknown has to do with a very pigeoned group of injuries. Thank you, Your Honors. Are there any other questions? I apologize.
Seeing none. Thank you, counsel.
Thank you, Your Honors.
Thank you both for your arguments this morning. Court will take this matter under advisement.